Despite the righteous indignation of the Walt Disney Company, Gina Carano's lawsuit has not been dismissed by the California judge in charge of that case. It's going to be moving forward. It's going to be going to discovery unless Disney decides to settle. Let's talk about that on That Park Place. Hello, I am Jonas J. Campbell, and I am investigative reporter for That Park Place, and here with me is Mr. VashSky. Vash, are you ready for some justice?
Oh, I'm always ready for justice and peace, as it turns out.
And some law and some order. Guys, we have brought in a legal expert like no other. You may not know his name, but American law has been shaped by this man's hand, or at least the arguments that he's made in front of the Supreme Court. We have got the legendary Ron Coleman of the Dillon Law Group here to weigh in on this from an episode of That Park Place Live. We wanted to cut out this clip especially for you so that you could hear his remarks. Now, it's going to be a shortened version of it. We'll be releasing a full version over on That Pod Place. Let's get right into it.
That judge.
Yeah, she really did a thorough job, and it was a real refreshing experience to hear something coming out of the Central District of California that actually acknowledges that studios and media companies are not the only ones with legal rights.
Yep. So I have questions, and you know more about this than I am able to perceive all the questions that I should be asking here. So here's what little I know. I see that this is 23 pages, and if we're talking about, first of all, her recounting of the arguments here, once we get to page 9, I believe this is where she starts to lay out her take on it. She being the judge, whose name is Peace, which is a kind of a hilarious pseudo-religious statement right there, but her name literally is Peace. Is it usual for a judge to have such a lengthy opinion? Sherilyn Peace Garnett, by the way, for those of you who don't know what I'm saying there. Is it usual for an opinion like this to be that long?
Well, yes and no. It is very common in the federal courts in California for courts to issue short memorandum opinions, which are basically previews of the opinion that they're going to eventually issue, and sometimes are meant to signal to the parties maybe they should reconsider where this is going before it gets official. Here, that didn't happen. Here, the judge took a little bit more time and wrote a fairly detailed but not over the top decision, which is a little bit probably longer than if one of us sued someone else here on the panel over the same issues. There's no question that
I'm reminded of your response on our behalf to Black Girl Gamer.
Yeah, well, sometimes less is more, but the judge is cognizant of the fact that there's a very good chance that this is going to be appealed eventually. And this is federal court. There are no interlocutory appeals, meaning that because this is not a final order that disposes of the case, if the motion to dismiss had been granted, it could have been appealed immediately by Gina Carano. But because the motion to dismiss was denied, the case goes into discovery now, and no appeal is possible until a final judgment is entered. It is possible in theory. The rules provide for Disney to ask for leave to appeal an interlocutory order. I wouldn't say that that's impossible, because they may argue that it will be the end of the world if you're wrong, judge, because the First Amendment is super important, and the judge is not likely to grant that. It is possible for a party then to go directly to the Court of Appeals, which is the Ninth Circuit. And the Ninth Circuit is, I'm glad to say, a little bit more of a mixed bag than it historically has been. It is still trends rather on the liberal side. But this judge has the liberal bona fides that I don't think they're going to be too quick to dismiss it. And it's really unusual to get leave to appeal an interlocutory order like this. Now, I actually want to address something else that you said, Jonas, about the recitation of facts in the case. You know, it is fun to get right into the legal discussion, but the facts are really important, and she makes that very clear in the legal discussion because she distinguishes the facts in this case from the cases that Disney relies on.
Yeah.
Equally importantly, what you see the judge doing here is tell a story that very much sounds like the story that Gina's complaint tells. I'm sure that the facts, let's remember, this is a motion to dismiss under Federal Rule of Civil Procedure 12b-6, which means everything in the pleadings is considered to be true if plausible. For purposes of asking, if all this were true, would there be a legal claim here? But what's important for people to remember is that the court was not weighing the evidence here. And in fact, one of the points the court makes not once but twice in the course of the opinion is Disney has asked us to accept its version of the fact, and particularly facts concerning what its motivation was for firing Gina, and facts concerning how Gina's comments might affect the creative product, the expressive product that Disney is putting out. And the court said there's nothing in her allegations that is inherently implausible. And she reminds the reader that the Supreme Court has taught that when there are two plausible theories of why something might have happened, it's not the court's duty on a 12b-6 motion to merely say, well, I find one more plausible than the other, which courts do. They're not supposed to do it, but they do it a lot. Here, the judge saw something she likes on Gina's side and something she doesn't like on Disney's side, and she did recite the allegations in a way that made you feel, by the time you got to page 9 and the legal discussion, that something wrong has been done here, and I hope there's a way for the court to help Gina get some justice.
When you hear Ron and others refer to the Unruh Act, that's a law in 1959 in California that was written in response to the blacklist. It said, hey, especially because the blacklist affected the movie business and it's California, it said you can't fire people or otherwise harm them in their work based on their politics. That is the law that's so key to this. And it's funny that it's being used by the very people who put it in to go after people like this. It's, in other words, it's be careful what you wish for. Someday it might come back to bite you in the butt.
In other words, the Unruh Act was meant to protect commies.
Right.
Well, in that case, I do want to ask, since Disney is essentially arguing against that bit of legislation in the state of California here with their claim here, if this goes in Gina Carano's favor, is there a possibility that it will set precedent against that act?
So the court makes it very clear that Disney's motion does not argue that the Unruh Act is unconstitutional. Rather, it says it doesn't apply here because Disney is in the expression business, and therefore defendants sued under the Unruh Act, if they're in the expression business, should basically be exempt for any anti-discrimination claim if they can plausibly allege that their expressive rights or their associational rights, two different First Amendment concepts, are affected by the employee. The court makes a very good point in a really cool footnote saying that there is no reason to accept, and I love it. I mean, I just love this. You want to go to page 17?
Yep, sure. Let me bring that up.
It's
here.
really worth going through with everybody because, given I know that you guys are a little bit more attached to the entertainment business than I am, but I think you're aware as I am of how these people think that they are just too good for the rest of us. Thank you. So again, Disney says that their message, their message, because they're in the message business, anyone that they associate with, anyone who have casting decisions, people who are basically artists, creators, should not be subject to this. And they say, don't worry, Judge, this is not a big deal. We're not making an exception that would swallow up the rule because it only applies to us privileged members of the creative class. And the judge says, I'm not. And the judge did not have to say this, but she says, defendants have not sufficiently demonstrated that this limitation is a meaningful one. If, as defendants urge, courts must defer to employers' accounts of what does and does not impair their expression, there is no reason why an engineer, accountant, secretary, or janitor employed by defendants, who by virtue of their employment with defendants are at least peripherally engaged in creating speech, might not be subject to a similar argument. Similarly, many entities outside of the entertainment industry create speech in some form, rendering defendants' proposed non-expressive employer category tenuous at best.
Yeah.
Now, the court does go on to say, to acknowledge, and this is something we've talked about before in panels where you and I have both been present, Jonas, there is, when it comes to casting decisions, definitely law that says to the extent that a casting decision has an effect on the message, we're going to defer to the casting decision because that is the right of free expression and perhaps even free association, but more like the free expression prong that we're not going to get involved with. At that point, the state's interest in prohibiting discrimination takes a backseat to the free expression. That's not what's going on here because, and again, this is all stuff we anticipated. Nothing that Gina Carano did had anything to do with the message of the program.
Now,
entirely extracurricular.
What I want to point out here is something that's also been brought up as detractors of this lawsuit have said, well, if Gina Carano wins this, it will set some kind of precedent to where Disney is unable to cast, let's say, race-blind casting, politically blind casting, gender or orientation blind casting. This is something that I think is well protected within the bounds of reasonableness and artistic expression. So I'm just trying to say that to make it clear to our audience and correct me if I'm wrong.
Right. Agree. The court makes it clear that we're not talking about casting. And also people should understand that a decision by a single district court is not binding on any other district court, even the same court, even the same judge. I mean, it technically not binding. But when you have a new area of law such as this is, you'll notice that the vast majority of the cases cited here are from within the last 10 years or so. Some of them are even within the last 2 or 3 years and refer to the cancel culture phenomena that have been litigated. It is fascinating, and the judges are the ones making a lot of these decisions.
We talk about the Overton window a lot. Before we say that, the judge has used one of my favorite 3 words here together at the end: tenuous at best. That is wonderful in a legal and argumentative standpoint here. The thing that I want to point out, that the cancel culture and that whole thing, and yes, cancel culture does exist, and sometimes it can result in people getting other jobs, let's say on the other side of the political divide here. But people said, obviously, Gina's not canceled because she went over and got a movie with the Daily Wire, a 3-picture deal, if I'm not mistaken there. But the Overton window here on what is, quote unquote, reprehensible, as Lucasfilm would like to call it, shifted so far to the left that even suggesting the idea that we need to be nicer to each other. Look at what happened over here historically. Don't you all want to be nicer to each other? Become some kind of endorsement of anti-Semitism. It's patently ridiculous. Again, to go back to this, my favorite 3 words in the document here: tenuous at best. But here we are. The Overton window shifted in a way that it should not have been. And I actually wonder if the events of, let's say, Saturday of a few weeks ago might have shifted it back here, as we've all maybe had a cup of cold water thrown on the nation. All right. I just want to remind you once again, that was an abbreviated version. If you're a nerd like me, you probably want the full version. For the full version, you're going to need to go over to
That Park Place Podcast's online
and hit subscribe. That will be releasing sometime within the next few days of this releasing on this channel. Of course, if you want the entire live stream that this was on, you can go to the members section and join up here. Our Tipcot members have access to the last 90 days of live streams on this channel on the archive. Thank you so much for being here. Comment on this video if you have any questions. Maybe we'll pass them on to Ron. And like this video if you like this video. And don't forget to subscribe to That Park Place for all the news that should be fun.
Thanks for watching That Park Place News. For more information, consider checking out www.thatparkplace.com. And don't forget to subscribe, share, like, and send this out on your favorite social media accounts.